A few words about Mira. She is one of the co-founders and a person who runs the Privacy Issues newsletter. If you, for some reason, are not subscribed to that newsletter yet, please do so. Please look it up and subscribe to it. And I know there are a lot of good newsletters out there, and probably too many, but Privacy Issues newsletter has probably everything that a good newsletter should have, which is, first of all, the content. It is greatly curated by several people. You can really see that there is analysis behind that journalism. It's not a sensation journalism, really. Then it also has a great design element into it, design aspect to it. It looks good. It's really interesting to read, which is also, I mean, not interesting only, but also visually, aesthetically pleasing to read. And last but not least, it comes only once a month, I think, or once per 2 months. I think it's a great advantage to a newsletter because if to me, for example, in the modern world, it's newsletter. If a newsletter comes too often, then at some point there is less and less motivation to read it. But yours, I'm always looking forward to be reading. And apart from that, apart from running the privacy issues, Mira is also a privacy consultant, and she works a lot and has been working a lot with startups, which is, I think, a fantastic topic. And I'm very glad to announce that Mira is going to talk about that in her presentation right now. I'm going to be switching off now, and I'm giving the stage to you, Mira. And dear watchers, listeners, please post your comments in the comments section below, and we will take care of them. Be sure to forward them to Mira.
Thank you very much, Maria, for this heartily welcome. I'm really happy to be part of this conference, and this is my honor and pleasure to welcome you all here as a first speaker of the conference. I will now share my screen to show you the presentation. So my topic today is startups and privacy, and I will be talking about struggles and advantages of implementing privacy early on. But first of all, let me give you a short intro into GDPR for those who might not be so deeply into the topic. So GDPR was introduced in 2016, and it came into force in 2018 as we know it. It is a long document of 88 pages, 11 chapters, and 99 articles, all of which find some application in the day-to-day operations of a business. And it deals with a standard collection, or it sets a standard for collection and processing of personal data of European Union citizens. But the trick is that it's not confined to the borders of European Union. It has global application because European citizens and residents, they live all over the world. And since this piece of legislation has to do with the data of European citizens and residents, that's why American companies, Chinese companies, or any other companies from abroad that process and collect the data from people of the European Union have to comply with this legislation. The most scary and the most alarming aspect of GDPR when it was announced was that fines for breach of GDPR provisions were quite high, and they range, or they may go as high as 10 million or 2% of annual revenue for lighter breaches, and they can be as high as 20 million or 4% of annual revenue for grave breaches. The problem and the challenge for all organizations that have to comply, basically all businesses that do something mostly online, is that there is no blueprint for compliance. So there is no real algorithm of how do you comply. I would like to show you the statistics of 3 years in GDPR application, and the statistics mostly are based on the fines, because I think the enforcement is one of the main criteria of how you can orient yourself in terms of risk mitigation and minimization. So as of May 2021, there are 636 fines, and total of the fines is 283 million euros. By a number of fines, Spain is leading the effort. The Spain Data Protection Authorities has issued 223 fines. Italian authorities, they have been most active in terms of the amount that was fined. In total, 76 million euros were awarded as fines or ruled as fines for breach of GDPR. You can see on the chart from the right that the fines has been gradually increasing, and it is to be expected that they will become more and even higher. So far, Google has been fined in France for the largest amount of 50 million euros. Google did not provide sufficient information about consent collection, and according to the Data Protection Authority of France, Google should have given more control to the users over how their consent and their data is being used. In H&M, for example, the fine of 35 million was issued because H&M was surveilling hundreds of its employees in a city of Nuremberg. The recorded conversations that should be strictly private, for example, those that employees had next to the coffee machine, or those insights that they shared after, for example, a long vacation with the management or being on a sick leave. So German Data Protection Authority has issued a fine ordering them to stop recording their employees. TIM mobile net operator in Italy has been fined for unauthorized marketing. TIM has been calling some of the users of its mobile network without any solicitation or consent with marketing offers, and as a result, Italian data protection authorities has received hundreds of thousands of complaints, and that was the result of these complaints carried out and enforced by Italian data protection authority. Although the total number of fines is quite large, we can safely say that the data protection authorities so far has not been able to fully exercise their powers because of lack of resources and funding. And this is just a small example of how does data protection authority budgets compare with revenues of the companies. Of some of the companies, for example, you can see that there is a comparison of Ireland with budget of Ireland, DPA with Facebook, Google, Microsoft. You can see Luxembourg, and you can see Amazon and PayPal comparison. So you get the idea that tech giants, they have enormous budgets, enormous revenues, and therefore enormous budget to comply, while the DPAs, they really struggle for resources, and that's why their work might be seen as quite slow. So also we can have a look at the information provided by Enforcement Tracker. What are the largest fines in terms of breaches? And the first three top breaches that I mentioned in regards with Tim, Google, and H&M, they were all in connection with insufficient legal basis for data processing. May I remind you that legal basis is one of the main provisions of the GDPR, because in order to collect and process data, any company has to really show their legal basis, and it could be consent. For example, if you see the marketing materials, if you want to receive the marketing materials, you have to opt out actively and voluntarily to receive these marketing materials. Data can be collected for performance of contract or legitimate interest. Legitimate interest is an interesting legal basis because this is not always easy to determine. For example, if you are a seller of shoes, what kind of data are you legitimately allowed to collect? That would be the question that this seller of shoes should be asking itself. Other legal bases, they are quite rare for business, for example, vital interest, legal requirements, or public interest. And I will not elaborate on them. I think the most important legal basis for companies is consent, contract, or legitimate interest. Another source of breach was technical and organizational measures. Technical and organizational measures set up in a company, they have to do with how the data is specifically protected within an organization. And that has to do not only with the physical and technical security, it also has to do who has access to data, how do you authorize your personnel and management to work with data and process it, what is the organizational structure, and what is the data management structure within your company. Are your employees aware that there is a data protection effort going on? Are they aware how to avoid social engineering techniques to minimize the risk of data leaks? Technical and organizational measures is a very important element of any data protection compliance program, and it has to be really paid attention to. And the third top most challenge for companies is compliance with general data processing principles. And general data processing principles are difficult for many companies because they do not have a specific instruction within the text of the GDPR of how to stand by these principles. It's all a matter to interpretation, a subject to interpretation. But I think when applying these principles, you have to really ask yourself, do you procure and process the data lawfully, fairly, and transparently? Is there a purpose for collecting and processing certain types of data? Do you collect only that data that is necessary? Is it an accurate data? Do users have the right and the possibility to amend if the data is not accurate? How long do you store the data? Is the data really securely stored, and is it securely collected? So basically, in order to check against these data processing principles, you have to ask a lot of questions and critically assess whether you really comply with these principles. On top of the existing challenges of application and interpretation of the legal provisions of the GDPR, there is evolving complexities that is coming from outside, based on political events or case law or various decisions by local DPAs. And one of them that sent shockwaves across the industry was the latest case of in so-called Schrems 2, which canceled US and EU privacy shield, requiring now the companies to set additional agreements between each other if they exchange data over the Atlantic between the US and EU. Also, Brexit has been quite a question of how do you apply and how does GDPR provision would apply to businesses that are doing doing something in the UK, or UK businesses doing something in the EU. So on 1st of January, as you know, UK left the EU officially. And in terms of data protection and GDPR application, European Commission and the UK authorities have agreed that for the first 6 months, alas, until 1st of June, there is unrestricted flow of data. Starting from 1st of June, there will be the adequacy decision that has been drafted previously by the European Union, where it says that UK for the next 4 years will be deemed a safe, adequate country in terms of data protection. So in 2025, this decision will be renewed or reviewed, and to see if UK is still the safe and secure country in terms of data protection. There are also new privacy laws within, in the last 3 years, there has been a lot of new privacy laws. And the reason for that is basically that GDPR set a really high standard for application. And if any company wants to do business based on data with the European Union, they have to live up to that standard. So, for example, Brazil recently adopted new legislation in terms of data protection. The US is continuously implementing and adopting new legislation. For example, the CCPA has been one of those legal acts. China, as I know, is going to adopt new legislation in terms of data protection. So all of them, these global landscape developments are very important, because for any company that wants to do business online these days, it is important to comply with the laws in the jurisdictions where they conduct business. The main challenge here is that because of these various legal frameworks that countries outside of the EU start inventing, it may get very difficult to comply on a global scale, because the data protection landscape is still very fragmented, and a lot of rules, they are very jurisdiction based. So in order to make sure that you have full understanding of how your product is being perceived, or whether it is compliant in different jurisdictions, you would have to look into these specific laws and see if just based on the GDPR compliance, you can transfer this compliance into that other jurisdiction. Also, in the last 3 years, we've seen that tech giants started to perceive privacy differently, and Google and Apple, those are very vivid examples of such shift in perception. For example, not so long ago, Google has created a privacy sandbox. This is an initiative where Google developers and people who work in Google, they have created various products that are supposedly aimed to enhance privacy. One of the latest rollouts was FLoC, Federated Learning of Cohorts algorithm, which effectively cancels third-party data sharing and collection. It is still in the testing phase, and it is to be seen if it's going to be adopted more broadly, not only in the Chrome browser, but it definitely started a really big shift in the advertising industry, where some experts predict that in a couple of years, no third-party data sharing would exist. Or, for example, you can look at Apple. Very recently, Apple rolled out a major privacy update where users have to explicitly allow or agree to behavioral tracking. And since there are so many products developed for Apple and Google, inevitably all of the tech companies would have to really follow these changes in the perception of privacy by tech giants and really try to navigate between the new privacy policies that were adopted by these huge companies and the general GDPR compliance in its purest sense. Last but not least, and this is not the last complexity, but it's just one of the highlights I would like to share with you. It's COVID-19, and COVID-19, as you witness right now, is affecting everybody. But for the business side, COVID-19 has sent a lot of workers to do their work from home offices, and that is a very difficult space to navigate in terms of privacy, because a lot of things are happening from personal home, from the privacy of an employee's home. And how do you make this disconnect between very private information and information that you need to do your job? This is kind of a paradox and a paradigm of this home office setup in terms of privacy. And I think a lot of companies struggle with that too. Well, so much for the developments in terms of privacy, but I think those, you cannot take out the compliance of a company, especially startup, from the context of what is happening in general in the privacy landscape. That's why I gave you this introduction in what is actually happening. You can also expect more complexities evolving in 2021 and 2022. These are just some of them. Of course, there will be more fine. There is a new regulatory regimes coming for digital communications or electronic communications based on e-privacy regulations. There is AI regulation that has been, the draft has been introduced very recently. There are a lot of pending decisions in terms of GDPR breaches, so there will be some landmark decisions expected by 2022. And as I mentioned, FLOC or cookie apocalypse, as they dub it, cookies may not exist in a couple of years' time. So maybe your organization is the one who has to really start the transition into first-party data or some other alternative ways to market your product. As for the startups, based on my experience, I can say that the main challenge for startups is lack of resources, because at the very early stages of development and of the idea and proof of concept, there is not much funding and not much knowledge or expertise is inside of the product or inside of the organization. Maybe there is a lot of expertise in terms of product or in terms of coding or development of a digital product, but everything that is not the core of the product is lacking. So, for example, it's very difficult for startups to find legal advice because it's so expensive. It's difficult for startups to plan how they will adjust to various changes in legal regulation of data protection and privacy. Also, the costs are punitive. So the startups have to decide whether they spend money now on something that is more or less leading them to compliance, or wait for the fine, you know, and both ways you don't save money. You just, I think in the first case, when you hire an expert and or find somebody who can really take over the compliance issue, that would lead to much more satisfactory results than, you know, being in a position where you are risking a fine. That's organizational challenges that inevitably affect compliance with GDPR for startups. Also, a lot of, I would suggest that instead of trying to kind of accumulate the necessary resources, if you are stripped of resources or if you are bootstrapped, that would be advisable to focus on three main things: privacy by design and default, trying to build in the product, the privacy, and test it in terms of data collection and processing. Make sure that data collected is secure and processed in a secure way, and there is some rudimentary, at least, data management and government, meaning that you know where you store your data, you know who is accessing the data, you know that you are really storing the minimal of data that is absolutely necessary for your product. So these three aspects that could be very helpful in order to understand and prioritize your data protection compliance program. I can give you some tips of how to minimize the risks. And generally, I would suggest to start with data journey. On your left, you can see an example of how that data journey could look like. So basically, when you are designing your user journey, think of the turning points when the data is collected or processed within your organization or shared within different departments or outside with different tools. And that would really help you to determine not only the legal basis, but also it will give you the very secure, very rational and very logical basis for drafting basic documentation. And data map and inventory are the most basic ones. Also, privacy policy and cookie policy are those that you have to have, because if you have a website that also has a tracking cookie, you just need to be transparent with your users and put privacy and cookie policy on the website so that anyone can have a look and see what the data processing practices within your organization are. That would be good to come up with a data breach emergency plan. So what do you do when there is a data leak, or what do you do when your systems are hacked? And that would be giving you some kind of a security, and also it will minimize the reaction time for you in case something happens. Another important aspect, and this is the most basic requirement, is that if you use third-party tools, like, for example, Google Analytics, or internal communication tools like Slack, or things like recruitment platforms or customer management systems, you have to find a way to sign the data protection agreements, because data protection agreements are the basis for sharing the data, personal data of your users, of your employees, with third parties. And you have to make sure that these tools that you are using are GDPR compliant, so that they can sign the data protection agreement. TOMS, we have briefly talked about technical and organizational measures when noting the aspect of breaches. So TOMS is very important. If you have TOMS in place, you have to make sure that you regularly check whether they are still up to date. TOMS is a living document, so you have to really, once you start changing, for example, the office space, or once you install new alarms, or once you start using some third-party tool that is to do with password management, for example, that has to be reflected in the TOMS. One of the other important aspects is employee documentation. Employee data, although it does not have a specific place in the GDPR text, is very important in terms of how you handle the data and how do you collect the data of your employees, how long do you store it. So employee data is kind of a different category of data from the user data, and it's very important that you have a mechanism to protect it as well. Two other aspects that I would love to mention, and I think that those are very important. You have to educate your team. Even if you are 2 or 3 people in the startup developing the product, you have to have the basic understanding of compliance, and you have to have the basic understanding of how to deal with GDPR implementation and how to answer basic questions, such as, for example, where do you store your data? How long do you store, and why you store it for so long? Why do you specifically collect this data? And is it necessary for your product? Did you get all the consents? So you have to have like a holistic understanding of GDPR compliance principles and of your maybe very basic but so necessary compliance program. And even if you're a team of 2 or 3 people, I think somebody has to take over the role of data protection expert, because that knowledge that is developed by the data protection expert, even from scratch, it will stay in the company. So it will straight away signal everybody, starting from your users to potential investors, that you really care about the personal data of your users, and that you are taking privacy seriously. Benefits from compliance are obvious, I think. Risk of data leaks, data hacks, of fines is being minimized. You will have the increased user trust, but also very important for startups, I think you will increase your value, meaning that when investors come to you with due diligence before doing their investment, before investing money into your idea, if you straight away set up the compliance practices that are adequate and that really take care of the personal data of your customers and users, that would indicate to the investors that you are really serious about growth and about development, because without the data protection principles, without data protection compliance, it will not be possible to grow your product and become a global market leader. And I think this is what investors are looking for, to invest into a company that will be a winner. And yeah, I think taking care of that part of development of your business is kind of crucial. I will finish my presentation with this, leaving you with these 3 benefits of data compliance for startups, and I am ready now for your questions. Thank you so much.
Mira, thank you so much for the presentation. It's a pleasure to listen to you. I have a question which might be not necessarily the one that is possible to answer in a short way, but I'm going to still ask this, because we rarely talk about privacy in the context of startups, and exactly for the reasons that you mentioned, which are the challenges of startup and dealing with compliance and all. And my question is, there is this mentality, which is very popular among startups, which is move fast and break things, which doesn't really leave a lot of room for things like compliance and risk assessment and thinking before you're doing. So what is your take on this? What is your opinion about that? Do you think that investors are really still, with regulations like GDPR, being, so aggressive and so omnipresent, so to speak? Do you think investors are really looking for this move fast and break things mentality? Is it something that really still works?
Well, that definitely works, but I think it works I mean, if you are developing a product that is, for example, designed to kill people, you know, this is an extreme example, but GDPR is a law. And if you are developing something that is meant to break the law, I don't think anybody would be interested, not even the most brave investors. So I think, yes, being disruptive and being creative is one part of developing a product, but it has to come with this code of legal compliance. And the good thing about GDPR, it does not set specific ways of how to comply, or, you know, it has principles, it has the provisions that are compulsory, but the way you do it, you can be really creative with that as well. And I think if you're a startup, you are in an enormously advantageous position in terms of compliance, because you can build that compliance as you build your product. And that's great for startups, I think. And it evolves, this like first steps of compliance would evolve with your product, and that would only benefit the product in the long term.
Yeah, absolutely. I absolutely agree with you that starting with privacy early on gives you a lot of advantages, even though it might look like a lot of work to take care of. And we will think about it later when we have at least the product to comply, to bring into compliance. I still think that designing privacy in and thinking about the processes and the documents early on gives you a big advantage. We have another question here from the audience, which is how to make these documents comfortable to use. And I'm not sure what is meant by these documents, but I'm going to assume it means the GDPR related documents, so the compliance related documents. So how to make these documents comfortable to use? Do you have an answer to that?
Comfortable to use. You know, I would say that you start lean in a startup language. You have to start with something very simple, so that because, you know, the product development takes a long time, you just make sure that you reflect the main data points you are collecting and the purposes of collection. You start with a privacy policy that is looking outside from your business, you know, that the users that are early adopters of your product can look into and understand what are your data protection practices, and just keep it short, keep it transparent, keep it simple. And as the product evolves, of course, you will work on your compliance further and it will become more complicated. But I think as a starter, to make it easier for everybody, for the company, for the product, and for your users, just start lean and but do something.
Mm-hmm. Yeah, fantastic advice, actually. Another question we have from the audience: have any startups been fined yet? And do authorities look after startups? Do you know? I'm actually not sure I have about it. Have heard about it.
Well, we know that, for example, Zoom is a startup and has been punished for insecure or for the system that had a security flaw. That's a US case, of course, but I think if the security flaw or the data protection practice affects immediately personal interests of a European citizen, that would come on the radar of the Data Protection Authority, and actually there will be a fine. Of course, in the media, I mean, there are a lot of, you've seen there are like 600 plus fines, right? Of course, there are some instances where the Data Protection Authority had to drop the case because of just, you know, setting the priorities. And if, for example, there is a chance to go after a bigger company and change the perception of privacy in general for all other companies, then of course the Data Protection Authority would really investigate the practices of a bigger company. But I don't think that it is excluded that startups will not be fined. I think on the contrary, if now the priority has been bigger cases, bigger revenue models, and bigger companies, slowly but surely the compliance will become, overarching for all businesses. And I think the earlier you start with compliance, the less problems you will have in the future. Now, if we talk about startups, it's kind of a investment in the organization, like internal investment. And also you have to remember that GDPR does not, the compliance of GDPR does not have a start date. So basically when the data protection authorities come and look at the company, they look not at the date when they started, but they look whether at all the company is compliant. And if, for example, the first privacy policy appeared on the website in 2021, while the company started operating and having their website in 2016, it's a potential for fine, because this is a very obvious breach of the GDPR. So I hope I answered your question.
Yeah, I would also add that there is, for those of the viewers who and listeners who are interested in the topic of fines, you might find interesting the resource called Enforcement Tracker. I think it is enforcementtracker.com, if I'm not mistaken. And you can browse through all possible categorizations of fines, by the country, by the amount of fine, by the purpose of the, not the purpose, but the reason of the fine, and things like that. And you will notice that many of the fines do not mention name of the company. And I think it is not excluded, we shouldn't exclude the possibility that among those not mentioned companies, there are a lot of startups and a lot of smaller companies where the authorities just decided not to disclose because the fine itself is harsh enough, so they didn't want to add the brand fine to it. We also have a few more interesting questions. One of them is, and we still have at least 5 more minutes. Startups, especially in the beginning, are fighting for their first customers and often making minimum value product with open source components with possible security issues inside. What would you advise?
Do not use these components that are known to have security flaws.
And there is a prolongation of that comment. Especially appreciate if you can share some hints here. Use some consulting options, open source materials, etc.
If I understand the question correctly, you want to know which tools to use.
I think this is what's meant. Yeah, I think this is what the author of the question means.
Well, there are lots of tools out there. I think you just have to do basic due diligence with whether or not this specific tool or specific piece of code is potentially dangerous for data protection. The main guideline is, if you have to choose a tool, try to find a European alternative for that, because most likely the data that is being shared with that tool would be staying in the European Union, so you wouldn't have issues of data transfers into third jurisdictions. Another question is, well, another thing is, I would really look into who is producing that specific tool or, open source code to see if there is kind of an idea for privacy awareness. And third, just check the website, check if there is like a sign of compliance within this tool, because that would mean that they care. That would mean that you can kind of trust the data of your early adopters with these tools. Also try to do data processing agreement with them before starting to use that tool. I think if you are developing a product that is very early stage, just you can try to develop it without a large collection of data. You can run simulations. So once you are at the product ideation stage, probably my guess would be that you don't need that much data at the first stages. But once you start looking for the first customer, you really have to set up some sort of a system that would later evolve into a compliance program.
Mm-hmm. Another question here, which I think is a fantastic question, and I hope we will be able to answer it at least broadly, which is how to minimize the risk in case of a minimum value product.
So that would be, it is very difficult to answer. I think minimizing the risks, if you are developing a product, so minimum viable product, right, MVP, think of whether at this stage you need to collect any data, in order for it to run some to show it to investors or run some tests, and try to set up some steps for compliance. If, for example, you are putting your product for wider use on through a website or through App Store or Google Play, think of very basic data protection policy. What type of data do I collect? For what purpose? How is it going to be used? If you're using tools for processing the data in order to run the product, look into them and choose those that, in your opinion, could pass this test of data compliance. I don't think it takes a lot of work. It's just research and understanding that if your product becomes available to more people, and if this product would be interesting for more people, you will inevitably face the question of data protection. And just start early with thinking of, how do I make sure that the data that I'm collecting through my tool or through my product, how do I make sure that it's protected?
Mm-hmm. I think another difficulty in that question, or in the way it's framed, is that when we talk about risk minimization in the context of GDPR, we often mean two different things. Sometimes we mean risks to the data subjects and their rights and freedoms. And this is what GDPR means. When you read the text of the GDPR, when they talk about risk minimization, this is what they mean, the risk to data subject. However, when we, inside of a company or as consultants and a client and or at a conference, when we talk about risk minimization in terms of GDPR, most probably we are talking about the fine risk, the risk of us being not compliant with the GDPR. And in that regard, it is a little bit different focus on looking at the GDPR. Well, not a little bit probably, but yeah, I totally agree with you that this component of the GDPR compliance, that is at least a basic text of data protection policy of privacy notice, or whatever you might call it, is probably one of the most important, because it is something that faces the outside world, something that is not only the information provision, which is absolutely crucial and important to provide the information to the data subjects, but also it is something that sort of represents you and your data privacy practices, right? So this is something that probably should be done well from the very beginning to minimize your risks of
yeah, but I think, the most important, I slightly disagree with the position that risk, when we talk about GDPR risk, it's from the company perspective, it is limited by the risk of fine. I think it is a consequence of not taking care of the personal data of the users. And in the end of the day, it boils down to the protection of data of your users. If you look at any product that is now online, the most popular ones like Facebook or like Zoom, now we're using Zoom. And if you think that as a business, as a company, you are using these tools and you are also as an individual, a subject to data processing done by these companies, it's just a question of how do you protect your own data. And I think that perspective for any founder or any person who is working at a startup and wants to do the right thing, I think this is kind of a perspective of a user and also a developer. How, if you want to do it right, do it yourself. So if you want to create a product that is right for everybody, for your users, and if you want to use it yourself, in the end of the day, you just have to take this perspective and sit in the shoes, in the seat of your user, because in the end of the day, if it's a good product, you will be using it yourself.
Yeah, great advice and great perspective. We have one last question, but I already see Sergey switched on the video and is about to throw it out.
Sorry to interrupt you. We lag behind the schedule, so maybe could this question be answered shortly, or it's more like requires comprehensive?
It's about the associations or services or guidelines that are specifically useful and applicable to startups.
All right.
If you know any, Mira, if you could share.
There is plenty of resources on the internet, but I don't think that there is like a specific resource that is an official guide for that.
For startups.
Okay.
Yeah.
Okay.
Yeah. Okay. Anyway, I'm gonna just thank Mira very fast. Thank you very much for your time and for your presentation. It's a pleasure to listen to you. And I'm so glad we have finally collaborated.
Yeah, I'm also, that has been my pleasure. Thank you for having me. And I just want to shortly say anybody who is interested in keeping up to date with privacy, just join our privacy issues community, sign up to our newsletter. Thank you.
Yes, do that.
Thank you a lot, Dr. Suleimenova, for your thoughtful answers and great presentation.